And your life.
Thank you. Welcome, everybody. This is the Senate Sexual Harassment Panel. And we are, we're missing a few members, but we are four of the six of us are here, so we're starting. Today, we are going to further review the updates of our policy with the hope that we will pass the policy. It may need further amendment, but at least get it as amended up on our website so we have a current policy. Then our hope is to next week or the week, or in the subsequent weeks, work on the procedures, which are different from the houses and which involve a little more, work. As you may recall, we're going to, I hope, come to the place where we can recommend this policy for adoption to our Senate Rules Committee. And that then a little different than the House, we then have to have the Senate Rules Committee adopt and pass it. So, and then it can be live on our website. So I'm hoping we can do that next week if that's possible. So we had walked through with Council Leonard the amended policy, and our Senate Secretary has made some revisions to it for our consideration. And so today I think we're going to begin with Senator Bloomer. Senator and Secretary Bloomer.
Good afternoon, Madam Chair.
You are, I think, not on camera. Would you be kind enough to step to the table just so people can see, or sit at the head, or whatever you want?
Do I have a choice to refuse?
No, you can. If you want, I know you love the camera so much.
Thank you, Madam Chair. So I had emailed out sort of some suggested revisions.
There.
Generally speaking, there was a joint. Oh, that's right. I have copies.
Two copies for it.
Yes, I'm so sorry.
To consider.
Sorry. You go to the computer one.
What?
That's mother email. Here. They and I can send you a PDF for the website, so you can find the page, or we can put it on whichever way you like it. So generally speaking, a number of years ago, as we've discussed before, there was a joint policy that was adopted by both the House and the Senate. It's the one that the Senate's been operating on since then, and put the policy and sort of procedures. Subsequently, the House made some revisions, try to address some concerns they had. As you also know, the House Sexual Harassment Panel is allowed to adopt their own policies and procedures. So it's a little bit different of a process as to how they're adopted in each chamber. So the Damian from Legislative Council, Damian Leonard, counsel from Legislative Council, have kind of walked through what the House changes were and what they've done. They started off with their basic foundation, the existing joint policy, and they made some changes to include, as I say, some additional considerations. So what we were instructed to do is to try to figure out where we had our greatest concerns, and by we I mean the Senate Secretary's office and the legal counsel to this particular committee. And Melissa and I worked through it. We had numerous suggestions, but under the guidance from this committee to make them as minimal as possible, the ones that were most critical to us is what you have before you. And I think generally there are only 2 or 3 really substantive changes. So and I will first make a comment before I walk you through. One of the things that dawned on us as we were working through this is that you have really 2 or 3 different things that you try to do in this overall policy. One of them is regulate senators, representatives, the staff of the House Clerk's office, and the staff of the Senate Secretary's office. You then really have a whole series of employees, which are in Legislative Council, which are in the Joint Fiscal, which are on IT, and that's sort of been restructured over the last few years. One of the problems in the earlier policies where we were trying to accommodate both, and they're still trying to accommodate both in this particular policy, but that creates some of both ambiguity and some of the issues of whether there's mandatory reporters or whether there's not mandatory reporters, who should drive the process and who should not drive the process. As an employer, you have legal obligations to take things or take correct me later if I'm wrong, but you have legal obligation to take steps even if the person doesn't want you to. If you're working with employment, there are some issues, there's some potential that depending on whether or not someone actually wants to address an issue given by a senator or by a representative, the policy currently sort of has them drive it, but there's always been this overlay that when an employer, with village council, with joint fiscal, what do they do, what do they have to do, and what are their legal obligations? So the first comment I made, I'm getting this, sort of the second paragraph, there is really, at some point, whether you do it now or sometime in the, I would hope near future, there is really potentially policy should have two components. One dealing clearly with regulated individuals, which would be senators, representatives, clerk, house clerks, staff, and the Senate secretaries. That's sort of one policy. You should, I believe you should probably have in here a little bit different policy for the ledge council, joint fiscal, and the IT. And the reason I'll try to explain that is they're clearly within that employment umbrella. There's mandatory steps that supervisors should probably take versus whether or not there's a complaint between the two senators at some point. And so this policy is by trying to cure all issues, sometimes does less than stellar on all of them. The last point I'll make before I move on is I can tell you that the original policy and the House changes were really done before human resources was sort of integrated. There was lots of changes. I say sort of because the House did make the changes after I think Arlene was hired, but the whole policy and the whole procedures that have been established through joint management, through the line to the various offices weren't in place. And I can tell you that at least I believe that if there was a dispute between two members of joint fiscal or between legislative council, this policy would require there to be a joint panel established to address it. I don't think that's what's done now. I don't think that's what you may want done. Generally, what occurs now, if there's an issue, they go to human resources and they work through it, just like a regular employer. So at some point, it's whether you do it now or in the summer, at some point, I think you would find that the policy would flow much better, work with the way that's actually it's occurring within the building by sort of separating those two up. I don't think it would take much time. And if you wanted to, we could propose something before next week. But I just wanted to really, that's the comment that I'm making at the beginning. Just so that you can adopt it, I think. Policy similar to the House with some of our suggested changes and move on. I'm not sure that does you full justice in the long run, but it could be a short run
It
solution.
gets the policy up on our website.
We already have a policy there. This will just make one that's consistent with the House.
Right, this would get us a little more permanent.
Yes.
And then we could do this additional work in this, as soon as you guys could work on this
Yeah,
together.
or we can do it, draft and send it to Damien or whatever. Because I know Damien swamped. We're not experts in this field. Listen,
Well, working with Arlene, maybe.
Yeah, Arlene. I've spoken with Arlene about this. I've spoken with joint fiscal chief. And I briefly spoke with Damien this morning. And because I wanted to know what they really would do, if they set up a joint panel or not. And one of my fears is, I haven't fleshed this out totally with David. I mentioned the past. What would happen if you don't follow the policy? And because the policy requires it and you do something different, what happens afterward? But I just started the process.
I think that in this case, it would be great if we could amend the policy after you do that work with Catherine, Arlene, Damon and you. And I'm happy to sit in and be, Molly and Molly's the new chair now, right?
Yeah, she's.
So maybe Molly and I could be brought in after you do your initial work and then we can present it to our committees, because I think that would have to be adopted by both bodies. Right?
On your side, you can, once again, joint rule, Senate rules could do it.
Well,
House
right,
could do it on this.
But I would encourage us to look at amending the policy that we've already looked at some of the changes. And that we, yes, give you a green light to start this work.
Sure.
And let's try and do it sooner rather than later and not wait till the summer. I'd love to get this work done and then we can move to procedures.
We will.
Is that okay?
Yes,
Great.
I will not.
Does anyone else? Any other thoughts?
I will walk you through. It is going to be pretty quick. I tried to use the drafting style you're used to. So the very first paragraph, there were various versions of this earlier on. Because it would only apply to the House, you talk about the Vermont House of Representatives. That real first paragraph is really a policy for the whole building. That's why we changed it to the General Assembly. The second paragraph is the same.
Secretary,
David,
can I back up to the title?
Mhm.
Oh,
yeah.
right, okay.
You're right. No, it's on a different draft of mine. I changed it, but I didn't.
Good.
When I couldn't-
At
Yeah.
right at the beginning.
So the question with the title would be whether you would call it Vermont Senate policy or General Assembly policy. Um, either way.
I think general, until we make this,
So so the problem really becomes, it's probably the Senate, because everything after you get to the second bold part deals with the Senate, and when it does on the House side, on the House. But I don't,
I'm okay with it being Senate and then the House having the House policy and they just like.
it's just, as long as they're similar and they aren't in conflict with each other, that is what we're trying to do.
yeah, these generally should be almost identical by the time.
Right. And
Third,
then we could call it.
third paragraph, all we're doing is flipping House, Senate, and clerk's office, and pro tems, and the speaker. Then you'll see that the rest of the page, you may note the suggested changes. It is different than yours. There are little things we might suggest, but that is not, both of them are very trivial, but it keeps the minimal amount of displacement. We didn't make any other suggested changes. When you get down to the bottom of page 2, there is some blue, which is very difficult to read. And so
I was gonna say, but it looks like it's redacted.
it's not, right, it's unfortunate, but, so it really is, the existing policy is the first few language, your existing policy is the person who's being harassed or potentially harassed can report. The stuff that is struck out is, or who had witnessed behavior by a regulated individual, which allows a third party to come to the panel. And so we sort of had a discussion as to who can be a complainant. There are 2 comments on this, whether or not you have to make a decision to delete this, even if you wanted to now. I'm not sure you do. What does that mean? Your procedures allow a formal complaint to only be filed by a was a victim, sorry, but a victim. So that doesn't mean that you couldn't have someone report what they saw. And so if you left this in and you didn't change your rules, your regulations, and how the actual procedures, you could still have somebody report something, and then it would be investigated, and the person who's the alleged victim would still be driving it. And so you could leave this in that somebody as a third party could go and report it through to one of you. But the House policy does have, procedure does have both, it can be reported by both a victim and a third party, and that once it's reported, it's my understanding that once it's reported,
No, stay right there.
you would have to have, once it's reported, the victim doesn't always drive the House process. And so you could leave this language in if you wanted to, without having the victim lose control when it gets to the later step, or you could take it out. But that's why it's in blue, is who can really start the process, and who can go to a committee member or panel member and say they've seen something that they think is a
So I can't read what is in this slide. So what?
Or
does it
who
say?
have witnessed behavior by a regulated individual that they believe is violation of policy. I have it on a screen, so it's easier to
Oh,
read.
and you know what? We can have it on the screen too, which given the
Remember, does an investigation automatic, is it automatic if this kind of thing is observed and then reported? Or do they go then to the victim?
Sorry, for the House and Senate, I think are a little different, and I think, I may be too strict on the House. I think the House, once it gets running, they have to do an investigation if there's a formal complaint. And I think somebody besides the victim can file a formal complaint in the House.
Okay.
a reporter.
Yeah,
So under the House policy, either the victim or the panel on its own motion.
and so the panel on its own motion could be if the third party came in, I guess. And right now, your procedure is a little different. But to answer your question, there's an informal process. Somebody, if I came to somebody in the panel and said I've been harassed, there are really sort of 3 different versions. You as panel members can talk to that person, give them what their options are. You're not mandatory reporters. They can get some information. The Senate has done it so that I would sort of drive what I want to do next. Then there can be a request to do an informal investigation or informal resolution, and that can be done with conversations between the input from both me as the victim and somebody else. They could go talk to the person who's responded, see if there was a way of addressing. I said something, if somebody said something really stupid to me, it was sexist. Don't think it should happen again. Simple conversation may resolve it. And so in that sense, our process allows that. There can also be a discussion about whether there's a formal complaint. It has to be writing process. Once a formal complaint is filed, that is usually sort of triggers, the committee meets, looks as to whether or not we use legal standards, whether there's a probable cause, sort of the legal, if we took everything as true, being correct, then it may be a violation of the policy, so you keep moving on. You also, before you do that, you submit the complaint to the respondent. Respondent has a right to respond. You as a committee then look at it, see whether it's cleared the threshold of a probable cause. Then you go through a process. If you do an investigation, you have the right to hire someone if you want from outside. You have a right to use still with internal, whether it be through Ledge Council or through our office or both. The house is a little different. They have a couple shells in there, which if we go that far, I'm going to suggest I believe that the policy in the house says they have to hire an outside investigator. And that's, I'm not sure if you want to do that if it's not informally resolved on a minor issue, but we'll get there some other time.
That's in the rules of procedure too. So that's where the two panels can differ. And it's worth noting that the House is looking at tweaking some of that language too, to provide more options for the complainant when they come to the panel. Especially if people don't fully understand what a formal complaint is versus an informal resolution and stuff like that. So, but yeah, that doesn't have to be driven by this.
But that's also in procedures and what we're
Yeah.
trying to do as policy.
I'm just trying to fully answer, I'm sorry.
Yeah, no.
So I did that too far off, but I wasn't sure if you were sort of asking what happens after you get one and who can control it. And so that's why I went off.
Yeah.
I know
That's helpful, very helpful.
So I
So
don't,
right now, a reporter, somebody who's witnessed it or a victim. That's what the House is, this is the change, is that a reporter who's seen something and or a victim could initiate a complaint.
could go to a panel.
Right.
And so.
And so I'm just gonna say, I think that is great. I do not want us to be in a position of somebody of it taking it beyond victim engagement, because I would not want to see it, a reporter forcing a victim to do something they don't want to do.
And I
Is
think.
that,
Yes, I think what I just want to make sure is there are some people that would be intimidated to speak up, particularly young people in the building and others, and that somebody witnesses something that witness can then bring it forward and have a conversation and then maybe direct it there with support or whatever.
If you adopted and included left the language in those house.
Yeah.
It's in blue, you can't read. If it suddenly came up with a bystander or somebody else came in to the panel, or if one of you came to me, I would probably say that if you had your existing procedures,
Right.
I would tell you should go talk to the victim, see if they're interested, what they have to say. And if they say they are not interested, then it's probably okay. Assuming it's not something that is criminal.
Exactly.
There are probably certain exceptions, but I mean, if it's a standard, I said something stupid, or I'm acting like a chauvinist pig, or I'm doing whatever I shouldn't be doing, that would then be allowed to keep within you as a panel member doing it like a consult, and as the victim, get to decide where they want to plug in, if at all, under our current procedure.
So my only concern with that, because I totally hear what you're saying, is in the situation where the victim does not want to move forward. But it's clear that the entity or situation could occur again, and not just to that victim, but to people like that victim, or just whoever happens to be nearby. I don't know. Do we then have a liability if we're not responding and we know that there was a situation? If someone's a serial person and enough people are like, oh, don't say anything, I don't want a situation to happen where we are then held.
So you're asking me schizophrenic question.
So
I don't mean, I don't mean yours.
it's
I
a
mean,
good
that's, so I think, in my opinion, there's two answers.
Okay.
And that's really wrong. Is it something that you've done to me? And do I want to go forward with it?
Yes.
Versus something that is done within the employees?
Mm.
I think if
Oh,
it's
right.
two people in joint fiscal, and once it's brought to somebody's attention, I think you may end up. More Jamie's actually, but I think you maybe create a legal obligation to do something. What bothers me most as your Senate parliamentarian and see is depending on depending on what's occurred or what's been said or what's happened within this building. The victim have control when it's a senator or representative. So I think there's a little bit of a
Okay. I
distinction,
understand.
but it also depends a lot on what conduct is. Once again, if it's criminal conduct, it's a little different, but if you and I were, two of you have a conversation. One of you said something inappropriate to the other. I witness it, I go to the panel,
Yeah,
and if the fifth time that one of the two of you complained about, should that be brought to the full panel, should there be a full hearing? I'm not sure, and I would probably tell you, but your current policy gives some discretion on how far you want to go. If it is two people that are like within my office, even though we're still under, so you guys, I would have to take steps. You know, if there are two things between two members of my office, I believe as their supervisor with an employment relationship, I have to do. So,
yeah, as an employer, you're exposing yourself to liability if you know about a situation. And you determine that it's, there's a chance of it repeating. And you do nothing,
That's good.
so.
But that's not. the
It's, yeah, it's harder to say with members because it's not an employment relationship between senators. And yeah, I mean, there's potential arguments under things like the Public Accommodations Act, but we're really starting to get into, it gets into issues of like the Senate's ability to judge qualifications for its members and other things like that, where the Senate really sets its internal policy. So I think I definitely agree with John that when you're an employer and it's an employer-employee relationship or it's between employees, there's potential liability if you do nothing. Among members, I don't have a clear answer on that. And so I think what John's saying is that you may need to treat the two of them differently.
Which is
for a
what
variety
he's
of
suggesting.
reasons.
And
And so I don't disagree with that. So I think the House has made the choice to try to treat them the same. The Senate doesn't have to follow that policy for its members. I would suggest you do it for your employees.
right, and we can, and
Oh, sorry, can you say that, so, I have a question and comment, so. I think you might have just said this, but I want to make sure that I'm clear, how does the House treat that situation if it occurs between members?
So the House policy is written so that if there's a chance of it happening again, they're treating members of the House as if they're employees of the House.
Okay, so, sorry. I didn't want
Yeah,
to-
that's fine. Yeah.
So, well, because that is kind of where my thinking was also going, and the reason being, so just because we are not obligated to treat the situation as if, we were gonna be liable. It's sort of separate from like whether we should, and it seems like, well, it does make me wonder if, so that, does the House have any protections around like, if the victim has not agreed to going to the panel, does the situation get to be anonymous? Like, is the identity of the victim protected? If they've not agreed?
Yeah, so the House is wrestling with this issue.
Okay,
And at this point, the way that they have looked at it so far is that if the victim is not going forward, then they try to figure out a way to address it that's now going to drive the victim into those resolutions.
and then, sorry, a couple follow-ups. So I'm not, I'm still getting the lay of the land with this policy. So are we in, would this be part of the procedures or would this be part of the policy that we're discussing right now?
So,
This is policy.
well, so there are points in this policy, and John can point them out to you, where he's marked it up with a strike through on the legal obligation language. And I'll let him speak to that. I think, I don't see a problem with any of those. I think it prevents creating a false impression in instances where there may not be a clear legal obligation. And then supervisors and human resources, if a staff person comes to them, they're gonna consult with counsel and follow whatever the legal advice is. In that situation, I think and I don't want to speak for John, so I might just stop here. But I think in the House policy, they've set out, there's a legal obligation, which in some instances may create the impression of a legal obligation where it's not clear because we don't have clear case law.
I'm feeling two conflicting tugs. Oh, sorry, Devin.
Do I want to answer, just because I want to make sure you have to kind of think through the process to answer your question.
Okay.
Because your question really is, if I'm a victim, can I keep anonymous too well?
Yeah.
The answer is no. No matter what you do, because depending how far it goes, the only way to sanction a senator, some senator. So you can go through a voluntary process. You as a committee, the House is a little different. They try to do, I'm not sure legally or not. But the whole idea is they basically can impose, you cannot impose a penalty. You can suggest it, you can do it informal. If the senator says, I'm not doing that, you have no recourse other than to kick it up to the rules committee. And then the rules committee, but the only time you can have a committee on committees take them off the committee. We've done that once before. But we're gonna want to know why. Last one was in the newspaper, and so lots of stuff going on. Or if you're going to actually do any kind of penalty, the body, because of the constitution qualifications of your members, are the ones who have to decide those penalties. And it's going to be very difficult for you to get on the floor and have somebody say, we're now going to say Senator Campy is not allowed to be a senator, and you're going to say why. And matter of fact, he has a right. He has a right to due process. If you're going to actually expel him, there has to be a whole. So the odds. One of the reasons the Senate did it last time was that if you really kind of follow through how you can do it, once it spins, the victim does not keep control if they really want to be secret. That's my opinion. I just don't know how to sanction.
More like a
Then-
reality.
So give me 10 minutes left.
Do it quicker.
So I feel that I feel comfortable adopting language John has proposed here, adding or.
That's actually the House language. Yours is the House language. I did not strike it, so that if you leave it in with all that little stuff, it's going to mirror the House, which is what you want.
I think that's good.
Okay,
Okay,
so yes.
yeah,
Then if you go on to page 3, you have one other quick one. Any person may request a panel, which is on page 3. It's the other little blue. That blue you cannot read either.
It says.
That says any person may request a panel attempt to involve informally resolve. And so that's really deciding how you do it, where does it go, what happens if they don't informally resolve it. So as a third party, I'm not sure it can't work. It will work really well when something's happened. And if I'm the senator, I want to get it done. Straighten myself out and move forward. But if an informal process doesn't work, what happens? And I think the way the House does, they can go forward. Do you want to be able to go forward? So it's on you. It's a change to suddenly say somebody who's a third party can request it. And that's why it's flagged. It would be different than your policies. That one, to keep consistent with your policy, should probably be taken out, even if you leave the other one in. Until you make a decision on what you're going to do with your procedure. Two
Okay, so
words.
that's a procedure dependent decision.
Yeah, and so at this point, I'd suggest you take it out just because I'm not sure you're gonna get there in the end. Not that you won't, not that you will, but if here's what also worries me, sorry to. We have a good state that people behave. So that if you leave this in, someday you may start behaving like other states or the national government. And this allows someone on the far fringe, away from wherever any of you are, file a complaint and ask for an informal resolution. Once there's an informal resolution started, if there is one, I have to keep a file. And what worried me when we talked about this before is, if you really want to, not that anybody's ever as devious as my mind goes, but if anybody really wanted to use this, you can never put a genie back in the bottle.
Right.
And someone says, have you ever had a complaint? It's gone through. And how do you address it? And how does it become a political weapon when you allow third parties to do it? Now, I would not expect any of it to occur now in Vermont. But sometime in the future, depending on the people, these files of these complaints, if they stay out there and can be consulted, do have a ghost, even if there's nothing there.
So you're recommending we take this
At
out?
least for now,
Yeah,
if you're
makes
going to
sense.
take this part out, you can come back, you can
Yeah,
revisit
we
it
can
or
always-
visit what you do.
Okay.
But this,
Yeah.
that, and they put out some of the
Okay, do this.
some of the decisions you make later on, you may want to put back in. But at this point, it's got some
So,
potential.
So.
so what happens to that sentence?
What I would suggest is take so from strike, so if you take it from may request and then insert it into the next sentence, so it becomes a longer sentence, but it says a person who believes that a regulated individual has sexually harassed the person or retaliated against the person may request that the panel attempt to resolve the issue informally or may file a formal complaint with the panel.
That's good.
That's fine. They look into writing to some other time. I think that sounds
good.
Yeah, and I'm tracking, putting in the changes here, and then I'll send the document back out so that it can be reviewed after the editors have corrected my bad grammar.
Okay.
So,
then the next one is there are three different, there's a contact appropriate piano, contact the supervisor, and contract with legislative human resources. And what's really being done in here is that there was language that said the shall ensure that it shall stop. And I thought that, right, and so I thought that's the legal standard. I didn't want to set up a separate legal standard that somebody in the plaintiff lawyer would bring a suit. So I tried to put in language that still says something's going to be done and legally required, like they shall take immediate and appropriate action to address conduct that violates the policy and shall take immediate right to prevent it. But I don't think any employer or anyone can ensure that it won't happen.
Exactly. We can make our best efforts and that would hold us liable, I think, because we can.
And we are responsible to take our best. And so that's what this language and all three of those, I think, is mirrored, is to just try to change it so that we're not setting up a new legal system.
I think
I
that's.
think that's all. You know, you need to help.
yeah,
And then-
and fine with those.
Yeah.
And then on page 4, where once again at the beginning, the second full paragraph, doing the House and Senate. We've also included legislative staff supporting the panel. The reason for that is that includes myself and Jamie. The House is staffed by the Legislative Council. Over on the Senate side, we staff it. At some point, they may or may not include Betsy Ann, depending on what the House does. This language here would allow to be covered by everyone. That everyone has to keep everything confidential. So that's what that is. And then at the end, we've taken out the ensuring sexual harassment conduct is not continued to put down and shall take steps to prevent it from occurring. The next paragraph, you, in our opinion, you cannot impose penalty.
But we can recommend.
Right, so that's why the impose comes out. Same one. And we made a change from the Senate to the House. We also put down that you're going to recommend corrective action to wherever it's supposed to go in the following one. And the next paragraph really deals with the Senate secretaries. The third paragraph deals with pro tems and the Senate secretary. What happens and where they can go. And it's just changing post to Senate. And then similarly, the last paragraph in that section, the policies of the House and the Senate, referring to the other body. And then the next paragraph, we're doing Senate and House. We did. There is the House has a little bit different, by rule, you have sexual harassment rule 101, which requires that the interns and various other individuals be registered with the secretary, sergeant at arms, but that the form that's needed is from our office, and that we're supposed to get notice. So that's why it says, and as required by applicable rule, so that it can be used in both chambers. When somebody registers, we're supposed to get notification. So that's that paragraph. The next one has nothing. The following paragraph does the president pro tem and Senate secretary to the speaker. That's because we're supposed to know what the information is. We changed this a little bit about Senate Rule 101, because in the Senate, the pro tem is responsible for the training.
Okay.
By the House rule or policy, it's the speaker and the chair. The next one, the next portion dealt with facilitators. I think David Leonard mentioned that at this point, there aren't facilitators with council.
You mean
The House,
other resources?
yes, the House, I think, is going to appoint some. One of the issues really becomes if you keep your procedures the way they are, you are the facilitators. Because you're not right now, you're not mandatorily required to take something that the victim doesn't want you to. One of the reasons that you had to have facilitators, I believe, in the House policy is they had to take steps or had to take an investigation if there was certain things. And so what worried me was that I think your policies, procedures are okay. I also don't know how many more senators you want to begin with 30.
Mhm.
You already have 2, 4, 6 on the committee. You know, you suddenly do 5 other facilitators. You at least currently the way it is, you are the facilitator. And I don't think it's harmful if the House leaves it there. I don't think it's harmful if the House leaves it in, but I don't think you need to put in the facilitators part for your version. Got it. Then there's no other changes until you get all the way down to the jurisdiction of panels where it's yellow. And the reason for that is that's my first comment. Nobody's going to, if it's in ledge council or if it's in joint fiscal or if it's in IT, I don't think the first place anyone's going to go is to a joint panel with chair.
Yes.
So in that sense, that's what needs to be, we're going to be working
So
on.
that's what we're looking
We're
for,
gonna work
you,
on.
Jamie and Arlene, back to come back.
And then on the next page, page 8, they have the House information. I did not draft out what the Senate information was, but we would insert the correct information.
Makes me feel good.
And that's it.
So, just bring us back to page 3. Under contact the supervisor and contact the Office of Legislative Human Resources. The first piece is, you had highlighted that regardless of whether the individual engaging in that conduct is a regulated individual, which, so for, and I think I want to just give you a chance to talk about that and make sure that.
But generally, this contact supervisor, legislative human resources, this is going to be potentially not in the next version of this when we get, because this really deals, I think, mainly with employees and or people that I would consider employees. So the language that's put in there, regulated individuals under this policy are you. If you look back earlier, the definitions. And so this is really talking about that other category. And so when I suggested we take out, regardless of whether the individual engaging in that conduct is a regulated individual, that is, I think it's redundant, one. I don't think it's necessary to be in there, though you have the ability to do that. And I don't think it applies to you as senators or my staff. And so that's why I was sort of taking it out. If you read the sentence without or the paragraph, an employee of the General Assembly may contact, that would be Damien, Catherine, it would be Kevin Moore, whoever has a right to contact their supervisor regarding any conduct that the employee believes may be a violation of this policy. I think that includes regulated individuals, and I think it includes non-regulated individuals. But that's, I think, by putting the other, potentially redundant, that's no.
I think that that's okay.
But I don't think it's necessary when you have the first clause 1 and 2. I think it then makes it look like we're trying to do 2 things within this policy that applies to the Senate. That's why I crossed it. Is that
Yeah, no, and I think it's a fair change. It was the House was trying to get at the idea that a supervisor has a responsibility, even if it's a lobbyist or who knows who harassing their staff person, they have a responsibility to protect their staff person. Especially if we go to a House policy, Senate policy, staff policy approach. You don't need this language. And the other thing is the supervisors and legislative human resources are trained and do train their staff on this. If you feel threatened, you know, it doesn't matter who it is. It can be the president of the United States or, you know, a random person off the street. You can come talk to them about it. So you can keep it or take it out, but it doesn't, you know, from what, as Senator Bloomer said, you don't necessarily need it for your policy, and it is redundant language. So
Then I boldly propose we take it out.
yes, so I just didn't want to dip past
Yeah,
that.
and I think so on purpose.
No, that's okay. Just wanted to make sure that,
So we need a motion.
so what I'm,
Oh, okay.
Don't, wow.
I guess what I would ask is, do you want me to draft up a revised policy with Secretary Bloomer's changes?
I would look, I think if it's okay with everybody, I would suggest that we meet next Friday to look at the revised changes and hopefully pass the changes, and even by then, we may, I don't know if you and Damien and Catherine will have had a chance to meet, but we could also discuss your proposal for how to address staff.
What I will probably do is, okay, is we'll take a look at it. And I will probably put together both parts. For now, because you're not going to address the second part.
Right.
Because the whole question is, we want to have something online, so we want to have a policy on the front, procedures on the bottom, the way ours is currently set up. We have the rule on top, so I'm going to take what Damon does, look at it, and then I'm going to come in with the second half included, so that you guys can look at both parts, see how they fit together. And then when you go to the Senate Rules Committee, at least now you've got a whole package, the current version of the changes, what you're going to suggest to the House and the top half. The bottom half, if you haven't looked at theirs, they're not going to look at yours. They do it as two separate documents, but we'll do it as one because we haven't.
Right, okay, I think, I'm sorry to eat up all your Friday lunches, but you know, by the time we get going, if we can be here promptly at 12:15.
Yeah.
My hope is next Friday to pass it on to the Central Committee, and as soon as possible. Thank you for your work, thank you, and then we'll start to work on the next.
Yes. Thank you.
So